our top debate, similar in a sense to what we debated last night. The right to privacy versus the right of the state to sometimes intrude. Yesterday we looked at the government trying to gain access to encrypted messaging apps. Today we are looking at what some would say is a very critical ruling at the Bombay High Court, one where 3 orders to tap the phone of a Mumbai businessman were put aside and the investigators were ordered to destroy those intercepts. Is this a major reinforcement of the right to privacy, which is a constitutional guarantee? So what exactly did the court say in this case? Well, this is the key point. The Bombay High Court said that phone taps can happen, but only if they are there for public safety. Does this verdict therefore reinforce the right to privacy? That's the big question. Interception of phone calls, the Bombay High Court said, is allowed only for a public emergency or a public safety. They set aside 3 interception orders which were cleared by the Home Ministry. These interception orders were directed against a businessman. The court said that the proposition that illegal tapping of telephone conversations violates the right to privacy is now accepted. The High Court said that the right to privacy is guaranteed as a fundamental right under Article 21. They also said that institutional safeguards are mandatory to scrutinize interception orders. This is a very important point. Who checks to see whether there are balances which exist in the system? The Supreme Court is also, remember, going to examine the government right to access encrypted messaging apps. That's going to be in January, so it's not this case, but certainly the question that needs to be asked is whether this particular verdict in the Bombay High Court actually has an impact on that as well. Joining us now, Dr. Sujoy Kantawala, senior lawyer in the Bombay High Court. He was the lawyer for the petitioner in this particular case. Geeta Bhatt joins us. Navneet Rajan joins us. He was the former CBI officer to get the standpoint of investigators in this case. We'll also be joined by Apar Gupta, the senior advocate, to look at the larger issues. But let me come to you first, Mr. Kantawala. Does this basically mean that security agencies or investigators cannot under any circumstances decide to intercept the phone calls of citizens in this country unless there is an emergency which takes place or it's in the interests of the state? Is that your understanding?
Right, yeah. Public safety, public emergency are the twin tests which have to be satisfied before you infringe upon a citizen's right to privacy, which has now been recognized by a 9-judge historical judgment in the case of Puttaswamy. So the Bombay High Court was shown this. The Bombay High Court was shown the 3 orders which were passed, and there were the differing stands by the police as well as CBI on which the Bombay High Court has commented on. On one hand they take one stand, on the other hand the CBI takes another stand. So the Bombay High Court says that when we are a country governed by a rule of law, if you have not followed procedure, due procedure, which ultimately violates Article 21, the right to life and personal liberty, then the court will not be blind to this. And according to me, that's a very refreshing way of looking at it. The constitutional rights and obligations, they also tested the theory of proportionality, the interests of the state vis-a-vis the constitutional rights of a citizen, which we all possess.
Okay, all right.
So what Puttaswamy, the 9-judge bench said,
we'll discuss a lot of what the 9-judge bench said and which was referred to over here. But Apar, let me come to you first. Apar, if you just if you face me over here, and then we can just this thing. There are circumstances in which intercepts can take place. Yes. However, they need to meet the criteria of public emergency or public safety. Yes. And then after that is satisfied, then if there is sovereignty or integrity of India that's affected, security of the state, preventing incitement to the commission of an offence, all of these things. So, what is the implication of this? How do investigators
Yes.
actually probe very serious offences, economic offences, for example, other offences?
Yes. So it's done quite routinely, Vishnu. As a junior lawyer who also assisted on the right to privacy case, these concerns were in the mind of the judges when they were laying down the right to privacy judgment. And what we've looked at is that there are certain safeguards under which there are procedures devised in which either the Union Home Secretary who delegates this power or the State Home Secretary who delegates this power, in which certain orders which are passed are then sent to telecom companies who then provide this information. But these conditions which are there, these are non-negotiables. These flow from constitutional guarantees. And if the minimum threshold of this legality is not actually met, then the court will set aside the orders. And that is what the Bombay High Court has done. Now, this judgment by itself, what it does is also a bit refreshing, because earlier there is a line of precedent which holds, irrespective of how you gather evidence, legal or illegal, it's always admissible as evidence. So this may be shocking for our viewers, but it does not matter as per a certain rule propounded by an earlier judgment of the Supreme Court, which was the R.M. Malkani judgment, that it does not matter how the police agencies gather this evidence, legally or illegally, it's always admissible as evidence. And because they may have done it illegally, you can possibly institute a departmental inquiry. What this judgment does...
That goes away.
It
gets
goes
tossed.
away. It says, after the right to privacy judgment in 2017, there's a sea change in the law and there's a way to relook at it. So if you gather evidence illegally, it can't be made admissible in court. And these procedures are what actually preserves liberty. It's not as the court is saying that you can't do telephone tapping, you can't do intercepts, you can't gather information on the basis of national security. These are the minimum thresholds and requirements necessary.
I think another very important part of this, Dr. Kantawala, is that the court has reinforced that there need to be checks and balances which are institutional checks and balances to ensure that even on those occasions when there is a tap that takes place or there is a request for a tap, that process by itself is vetted. The court ruled that and they were referring to the earlier case, the court ruled it would be necessary to lay down procedural safeguards for the protection of the right to privacy of a person until Parliament intervened by framing rules under Section 7 of the Telegraph Act. The court accordingly framed guidelines to be adopted in all cases envisaging telephone tapping. The argument made by the government is that this checks and balances already exists. It's not that a policeman can order a tap and a tap takes place. It has to go to the Home Ministry, it's vetted within the Home Ministry, and I believe it's signed by the Home Secretary before it used to take place. Does today's judgment mean that even further to that, there needs to be an institutional safeguard?
In fact, it is there. The High Court has taken that into consideration, that there is a review committee established under the rules, and the review committee has to vet the orders. They have to okay it. So if that procedure is not being followed, then the intercepts are liable for destruction. And when the CBI came out with different stands, said that we'll produce the evidence at the material time, the court said nothing doing. So there was a contradiction between the state police and as well as the CBI, and the High Court has commented severely on that. That therefore the High Court has said that we are ordering destruction, though it is deemed to be destroyed. If it is not destroyed, we are ordering the destruction of the. You cannot use this as an evidence in the trial before the lower court. So that is very important. That's a very important observation, because there is a we come across every day phone intercepts which are taking place, and then the police machinery with certain criminals, they enter into unholy nexus and they extort monies. The citizens are at peril. So therefore it is only under 226 that the High Court is the remedy available for such cases. Now, and the High Court therefore has held that if we don't interfere in such a case, we will be breeding contempt for the law.
Okay, Navneet Rajan, as a former investigator yourself, somebody with the CBI, is this something that affects the ability of investigators to get ahead of a crime?
Let me put things in perspective. First, this is not the first judgment in this case. A similar judgment was passed by Andhra Pradesh High Court way back in 2007 in a case where a telephone of a very senior CBI officer was intercepted and he was caught red-handed taking bribe. It's the first case when the Andhra Pradesh High Court gave a similar judgment, which is much before the right to privacy was enshrined by the or explained by the Supreme Court to be read in Article 21 of the Constitution. That's one thing. Second, now this section 5(2) has two limbs, as some the panelists correctly pointed out. Either there is a public emergency or in the interest of public safety. Either of these clauses have to be read with subsequent that in the interest of sovereignty, integrity of India, security of state, friend relations of
No, but sir, my
with
question
foreign
to you is
states
specific.
or public order.
Sir, my question to you is specific.
Yeah, I am coming to that.
Yeah, so if you can answer my question, how does this impact investigators from getting ahead on a crime?
I am coming to that. You see, it's necessary to answer that question to give some background. Now, this act was enacted in 1885. Now, if you read this section corresponding to information technology section 69, now section 69 is worded totally differently when it was realized by the lawmakers that it is necessary to intercept communication for the
no, but sir, I'm sorry, sir, you're still not answering. I understand the legal aspect of this. I've read out a lot of what you're saying, but my question to you, as an investigator, does this mean that your hands are tied? I'm asking you this for the third time, sir. As an investigator, your standpoint.
Yes.
Right. And how so, sir? What is the potential impact? Yes. What is the potential impact, sir?
You know, the potential impact is in cases of economic offences and cases of corruption. The investigation agencies will not be able to intercept the telephones of any individual as enshrined in this section. So, that will be the difficulty. It was difficulty earlier also, not that this is a new interpretation, this was old interpretation, but the investigation agencies were taking recourse to this section and putting these telephones under interception.
Okay.
But now with this Bombay High Court judgment, which is second, this will definitely going to create problem. The law will have to be changed.
So, let me come to Geeta Bhatt. Geeta, you know, I mean, it's the law. I mean, it's a particular ruling. But you know, in the context of something else yesterday, which was actually related, whether or not the government should have rights to get into encrypted communications between those on social media networks or messaging apps, you had believed that there were circumstances in which the government should be involved, that there were things that needed to be checked. But in light of this, you know, it's different forms of technology, but there is a precedent which has been set. Do you believe that that can no longer take place in the case of social media or messaging apps, that the government essentially cannot intervene unless those two grounds are met, public safety or an emergency?
Well, Vishnuji, you know, in this digital age, in the 21st century, there is an echo, if you can please correct it. As far as we are talking about the various dangers or threats, you know, these threats, if being as is being proposed, that if these threats are from the state, there are also so many cases where there are non-state actors, you know, who are posing a lot of threat and danger, whether in terms of you know, personal interference or whether it is in terms of national security. So, as far as if we try to look at in terms of this case which is being discussed as of a businessman who it seems whose phone was tapped in between 2009 and 10, similar kind of judgment, this kind of a judgment, there are so many other judgments, if you can please correct the echo. There are so many judgments where the judgments have stood with the citizens' right to privacy, and they have held it integral to the right to life. Now, see what is and one of them, if I can remember, is the famous 1997 People's Union for Civil Liberties case, where specifically in terms of telephone conversation, it has been recorded in the judgment that an individual in the house or in the office has got full right to have a private conversation. And as you also mentioned, in the Indian Telegraph Act, there is a provision which categorically says that the state or the government has a right to intercept telegraphs, portions of telegraph, which also includes telephonic conversation. So
yeah, but the point is there are circumstances.
If you can please get it corrected.
Yeah, Geeta, we'll come back to you. We'll try and get that corrected.
Yes, there are. That is why.
Yeah.
That is, Vishnuji, I just want to add here is that, so what is needed is that there has to be a very careful and sensitive balance between an individual's interest and that of the, the legitimate case which is being raised by the state or by any investigating agency.
Geeta, I appreciate what you're saying, but I think the law has been read, and it's not a sensitive balance that they're looking at. They've spelled out what can be done and what cannot be done. They've spelled out, is there public safety which is being violated? Is there a public emergency which is being violated? Then we can look at that. So there is no sensitive handling or there is no balance per se. But Apar, is that correct?
So I think
this spells it out. And does this apply to social media as well?
So Vishnu, the legal architecture which emerges largely is from the 1996 People's Union for Civil Liberties judgment. The safeguards which have been put into law first arise from the statute, which is the Indian Telegraph Act, section 5.2. That's what you're reading.
Yes.
And the procedure was devised under the rules, Rule 419A, after the PUCL judgment, which laid down what should be the processes. The process basically centralizes all authority within the center, executive bodies and policing bodies, or within the state. So who issues the order? It's the Home Secretary or their delegate. It's enforced by the police departments. There's no checks and balances in terms of a judicial oversight. There's no parliamentary reporting. And as per RTIs, which were last responded by the Home Ministry about 3 years ago to the Indian Express, the Home Secretary was objectively issuing about 3,000 to 4,000 tapping orders every month, which means the Home Secretary, which is one person, was applying their mind in a set of factual circumstances individual to each case and issuing an order for tapping, which means they did not have time itself to actually evaluate a case and order a tap. The second thing is the review committee which is there composes of the same people and nominees from the union executive or from the state executives. So basically there's a large amount of political control, and what happens after that? The tapping order is destroyed. So these kind of instances are rare because the information which is submitted in trial, when you're actually prosecuting a person on the basis of evidence you have gathered, a judge looks at it, and because a litigant has gone to the High Court and has said, you gathered this information illegally, and these instances are rare, the judge actually says, yes, you have all the powers, and even then, you have not done it properly. And there are factual inconsistencies in the stand of the CBI, as Mr. Kathawala was just pointing out.
Okay, I just want to go back. I just want to go back to Mr. Kathawala because there's another very important part of this judgment. The question which many would ask is, all right, fine, public safety and public emergency can be all-encompassing terms. If I, as an investigator, should argue that if there is corruption in an economic case, it does represent a threat to public safety, it does represent a threat as a public emergency, then that could be one way of going around this judgment. However, what is important over here is that this has been spelt out. What is public safety and what is public emergency? I think this is significant. It says the expression public safety means the state or condition of freedom from danger or risk for the people at large. Neither the occurrence of public emergency nor the interest of public safety are secretive conditions or situations, right? Either of the situations would be apparent to a reasonable person. Public safety or public emergency cannot be a secretive sort of condition. Mr. Kathawala, what is the implication of this? This definition, two definitions.
No, Apar was right. Apar was very right when he explained that part. Now, Bombay High Court judgment relies on Menka Gandhi, and in fact comes to the conclusion that if a citizen approaches the constitutional court, then the state has to come forth and justify as to how and on what basis their action fell within public safety and public emergency. So there will be a judicial review. The High Court, under its extraordinary jurisdiction, will come to the aid of a citizen, because the High Court says we are compelled to do that. If we don't do that, we will be breeding contempt for the law. Due procedure has to be followed as enshrined and laid down under Article 21. Otherwise, what is the point in having a constitution? What is the point in having a 9-judge bench in which my friend also had taken part as a junior lawyer? So what is the point in having all this? Because we are a country governed by the rule of law, and therefore the procedural safeguards which are in place have to be followed. It is an indefeasible right of a citizen in this country.
Okay. Geeta, last word to you. Now that this has been spelt out in the manner that it has, do you believe that this will have a fundamental bearing to investigators, to the government, as it goes after different types of offenders, even those involved in allegations of terrorism?
Well, I think within the judgment, this much in fact, not only in this, on almost all the judgments, including the one which Mr. Katawala was talking about with respect to Menka Gandhi, you know, this in every judgment there has been the scope that here it has been defined in terms of emergency, or somewhere it has been defined in terms of national safety. So everywhere this much of space has been given by the judges, where they have mentioned it that, you know, if it is related to anything that has a legitimate aim, whether it is national security or investigation of any kind of crime, or, you know, trying to retrieve any kind of information, so that much scope needs to be given to the state and to the investigating agency. Otherwise, somewhere it is going to hamper or, you know, pose some kind of an imposition in collecting some very vital or crucial information. So again, you know, it may be a kind of a catch-22 situation.
All right, a catch-22 situation, but I think at the end of the day, whether the government chooses to follow these guidelines, it's one thing not to present it to the court, but it's something else to believe or to hope that our investigators actually do not get into phone taps on a proactive basis, irrespective of whether they actually submit it to a court or not. I think that's a larger issue, but our investigators do obviously need to carry out their functions as well.